seated. The matter before the court is a Rustic 23-450, State of Maine versus Pedro Rosario. And we are being streamed live on the web, both by video and audio. If counsel would identify yourselves by saying your names for the record, together with the party you represent, starting with appellant.
Good morning, Tyler Smith for the appellant, Pedro Rosario.
Matthew Hunter for the appellee, the State of Maine.
Thank you. Counsel, if you're ready to proceed, we'd be happy to hear your argument, Mr. Smith.
Good morning, and may it please the court. The right to a jury trial is an essential ingredient in a fair criminal proceeding. It's akin to the right to a public trial, the right to counsel, and the right to an impartial decision makers. Trial courts, to that end, have a responsibility to safeguard and preserve the lawfulness and the integrity of the jury's composition. And unfortunately, in this case, the jury's composition was defective. Juror 23 was an alternate juror, not a regular juror. Juror 23 was never elevated by any order or decision of the court to regular juror status, and there was no basis in the statute for excusing one of the regular jurors in favor of juror 23. And the result of this is that Pedro Rosario now stands convicted, serving a 15-year sentence on a jury verdict that was returned by 12 regular jurors. Now, timeliness is obviously an issue in this case, and I would be remiss to not notice that this is not brought in an ideal procedural path. The bottom line is that Rule 33 has been interpreted with some flexibility by this court, such as in the Rankin case, where we had an untimely motion for a new trial under Rule 33, yet this court did consider the issue that was raised. And here, we have the trial court, despite there being an objection to timeliness, still going ahead and considering the merits of this very important issue that Mr. Rosario's counsel brought forward. And I would also note there's been no suggestion of prejudice by the state in the timing of this. And at least from my review of the record, I see no advantage that would have been gained by Mr. Rosario for sitting on this issue. And so therefore, I would ask that this court likewise review the issue. Thank you, and I'll waive any further uninterrupted
I'm going to start
time.
there then with the timeliness issue. In this case, as I understand it, selection occurred on May 13, 2021. And that's the event at which the question about the voir dire of Juror 23 and Juror 23 being seated as an alternate really is raised, correct? Well, I guess the alternate happens at trial, so I'll back that off. So the voir dire is on 5/13.
That's right.
Then you have trial, and the trial is on June 1 through June 3rd, right?
Correct.
And it's at that point that Juror 23, who was supposed to be excused as the alternate, instead a different juror's excused and he sits, right? Or she sits.
That's correct.
All right. Then counsel goes to a voir dire in a different case on June 14th and finds out that Juror 23 may know the DA, or does know the DA, right?
That's right. I don't know at what point the connection was made in relation to this case, but that's when trial counsel
okay, but at that point, we don't even
information.
have the judgment. In other words, the judgment isn't until sentencing of August 27, 21.
That's right.
So the 14 days doesn't begin to run until August 27th of 2021. Do you agree with that?
Yes.
And so at this point, all the information is available, has been available for some weeks, if not months. Why shouldn't that 14-day apply?
Well, Your Honor, the bottom line was that the trial court did decide to move forward and consider the merits of the issue.
And we're
I'm not
reviewing
disputing.
the trial court.
I'm not disputing that it was untimely under the plain text of the rule. I think that's
But do you agree
inescapable.
there's no reason? I mean, let me put it a different way. If we had a case where information about the juror came to your attention or came to counsel's attention, say months later, in a different voir dire, but it was months later, maybe that might give us pause. But in this case, all the information was there and available to counsel weeks, if not months, before the final judgment or before the 14-day. What is the standard? Are we just going to ignore the 14-day?
Well, I think it was incumbent on the trial court to make that determination. There was an objection based on timeliness by the state in the trial court, and the trial court still moved forward to consider this issue.
Isn't that an error of law that we would review de novo, however?
I disagree unless there was, I think it's an abuse of discretion standard, and unless there is some evidence that the trial court misunderstood what the law was, the trial court would have discretion to consider whether to entertain the motion, particularly given this court's decision in Rankin, where the court did consider an issue that was raised more than 14 days after. And although I don't have the rule right in front of me now as I'm thinking back to it, I think the rule actually refers to 14 days after the finding of guilt, not necessarily the sentencing. So that date may have been after June 3rd. So again, as far as the timeliness, I think the issue really comes down to the fact that the trial court did elect to consider the merits of the issue that was raised. The trial court had the opportunity to discuss with counsel whether the issue warranted consideration beyond the 14 days, and ultimately didn't find any reason to deny the motion on the ground of untimeliness.
Counsel, putting aside timeliness for a moment, two questions. Do you have any authority at all that stands for the proposition that an alternate juror who becomes part of the regular jury panel in the course of a trial is improperly appointed? And secondly, what prejudice is there here? Did Juror 23 say he could be fair and impartial? And if so, don't we honor those representations?
Sure. In the manner in which your question is phrased, the answer is no, there is no authority. But the premise of your question is the alternate juror becomes a member of the regular jury panel. And the argument here is that that didn't effectively happen. What happened was the trial court mistakenly discharged one of the regular jurors and sent the alternate into the deliberation room. The most analogous situation that I was able to locate in my research was the situation where you have an alternate juror who is sent into the deliberation room with the 12 regular jurors, and how courts have handled that situation.
But that's a massively different situation, and you've got an extra juror in there. But in this case, even if this individual was part of the principal 12, you'd be in the same scenario, right? Because he had not been challenged at any point prior to that, so the fact that there was a mistake in sending him in doesn't really go to the heart of the matter. It's the fact that the information about this juror came to light after the fact. Am I correct on that?
Well, it's not just the information about the juror. It's the fact that he was an alternate juror who was never promoted to being a regular juror in accordance with Maine law. There was no basis under the statute.
I think I understand you now. You're saying the mere fact that an alternate, the wrong person was released, so the makeup of the jury changed from what the court and the parties had thought it would be in the first place.
That's right, and that's why when I opened, I was talking about the ingredients of a fair trial, because there are some things that are simply so important.
But standing alone, getting back to Justice Douglas's question, if that happens, let's say it happens generically, judge lets the wrong person go, and the alternate is part of the 12. Standing alone without anything else, is that reversible error?
I think that is reversible error.
Why?
Because
and I think Justice Douglas asked you, do you have any authority for that? And I think you said
I was not able to find
Okay.
any case law either way on this issue. This appears to be a pretty novel situation that happened.
Okay, can I ask you, in the short time you have remaining here, I think you conceded that it's not newly discovered evidence. This isn't something that would come in a trial that's exculpatory, that it is in fact new information. So, as you know, there's a pretty exacting standard for newly discovered evidence. If we accept your proposal that we should look at new information, should we use the same standards we use for newly discovered evidence? And I see two fairly large hurdles there, that it would probably change the result if a new trial was granted, and it could not have been discovered before the trial by the exercise of due diligence. So if we import the newly discovered evidence standards to new information here, number one, should we do that? Number two, how can you survive those hurdles?
I don't think that the court can do that, just in the sense that the new information, the legal issues are so different. When you're talking about new evidence and you're talking about evidence, if had it been admitted, would it have potentially changed the outcome of the trial? Whereas here, we're talking about really a structural flaw.
So we should not import the newly discovered evidence standards?
No, I don't believe that would be appropriate, because it's...
So if you're writing the case, what's the standard? What would our decisions say that we, as the appellate court, need to look at in determining whether or not the new information justified vacating the conviction?
Well, in this case, what I would write is that this indicated a structural flaw with the underlying trial, because there were only 11 properly seated jurors who returned.
So you're saying it's like if you suddenly discover that the lawyer for the defendant isn't a lawyer. It turns out that he was entitled to a lawyer and he didn't get a lawyer, and now what do we do?
I think that's a great example. Let's say you had a situation where you find out the person wasn't properly barred as a lawyer, but they effectively represented the defendant. I think there would be very few people who would have any hesitation to say that that would potentially be a structural error.
Yeah, but
Or
the
Let me ask you
the
this
difference
then.
here is that this juror was qualified.
Yeah.
Fully vetted.
Right.
Well, I disagree. I don't believe he was, because, again, he was an
He was
alternate.
qualified to
the
serve as
other-
an alternate.
I mean, if the other had been taken sick, the alternate was fully qualified to sit as a juror, correct?
Absolutely.
Okay, so
Absolutely.
when you say wasn't actually seated as a juror, what is it that you think had to happen at the trial when the judge says, okay, juror number whatever it is, you go home and the rest of you go out and deliberate?
I think what had to happen is what's listed in the statute, that a regular juror became unqualified or unable to perform their duties.
Well, through inadvertence, a regular juror did become unable and unqualified to
home.
perform their duties. The person left the courthouse inadvertently as a result of the judge's instructions.
Well, that's...
We now have a panel of 11. And somehow you think that the alternate at that point can't become part of the juror panel?
Well, it was unfortunately a mistake of the trial judge, and I understand how that could happen. It's certainly a reasonable thing. But as I mentioned at the beginning, there are
And no objection by
certain...
counsel, right?
And counsel. It was certainly something that was throughout the courtroom. However, there are some parts of... See the red light.
Finish your sentence.
There are some parts of a criminal trial that are simply so fundamental and so important that a mere mistake can require reversal.
Thank you.
Thank you.
Mr. Hunter.
May it please the court, I'm prepared to take any questions, Your Honor.
Was this a structural error?
I don't view it as that.
Because that has some implications that are pretty profound.
Yep. Your Honor, so we were all present at the trial, or I say we all, the judge and the defense attorney, myself, when the judge released the alternates. And there was an opportunity to object at that point. Obviously, there's no objection. And then there was the first appeal of this case that we argued almost 2 years ago. And I think if this issue had been raised in the context of that original appeal, the court would be reviewing it for obvious error, and we'd be talking about what was the harm caused by releasing that other alternate. They're all equally qualified to serve as jurors, and so obviously there was no harm to anybody.
I mean, I'm going to ask you the same question. What should the judge have done to make it clear that this juror, was there something else that needed to be done to make it clear that this juror was going to be promoted, if you will, from alternate to a full member of the jury and to deliberate as a full member of the jury?
Nothing that I can think of. Usually when we do that, the jurors don't know who the regular members are or who the alternates are. The judge gives a speech. You know, he says, we've reached a kind of an unfortunate part of the trial. I always hate to do this, but you were important. You and you have to go home now. And he doesn't address the people that are remaining. Everybody's operating under the assumption that they are going to be making a decision, and then two people get the bad news that they're not going to be included.
Let me give you a hypothetical, not this case, but another case. Same thing happens. And at a later voir dire, where individual voir dire is taking place, and this juror says something like, well, if they weren't guilty, why did they arrest them? This is just a lot of nonsense. They're trying to get off on technicalities. This country is going down the tubes, and we need to convict these people and get them in jail. Something really inflammatory that would bounce them for cause. Let's say, in my hypothetical case, that happened. Does that change the scenario?
So this court has cases addressing juror bias that came to light after the verdict. And two things needed to be demonstrated. I think one was that the language from the case laws failed to answer honestly the question, but I think failed to answering it accurately would be sufficient. And then a correct answer to the voir dire question would be a valid basis to challenge for cause. So if you've got somebody showing up, presumably if the issue is raised within 14 days and the court believes them, accepts that as true, I think it could be a little bit different. There are cases addressing juror bias.
As juror misconduct in that issue, as opposed to newly discovered evidence for purposes of a motion for new trial, as I understand it.
Yeah, when I read those cases, this was a motion for a new trial based on newly discovered evidence.
I understand.
But when I reviewed those cases, I think the factual issue that came up, the one that jumps out at me was one of the jurors was alleged to actually know something about the defendant or something about the case.
Right, so we have a number of cases. We have Chesnell, we have Watts, we have Sabatis, we have, I think there was another one, Gatcomb being the big one.
Yep.
Where there's a question raised about juror impartiality, misconduct, et cetera, and it still is analyzed as requiring the 14-day rule, right?
That's my understanding. I don't think it came up.
Here's my question to you. What if it turns out, under Justice Meade's scenario, that this juror comes in and answers these questions and it's in this incredibly inflammatory way? In other words, as a matter of fact, we would say, yes, that is a juror that is biased or whatever. But that information does not come to light until more than 14 days later. What do we do with that?
If an evidentiary hearing is conducted and the trial court accepts that as true, like there's an actual finding and not just an allegation of that, perhaps your issue doesn't arise under Rule 33 so much as it does under the Due Process Clause of the Constitution. That would seem to render a trial unfair.
Well, we've said it's raisable on PCR, but that seems like kind of an odd way to raise it in some ways.
I know there are PCR cases where the issue isn't necessarily the attorney deficiencies, just the fundamental unfairness of the trial, and so it would seem to fit within that context as well.
Counsel for Mr. Rosario has argued that the trial court below essentially uses discretion to take the claim more than 14 days after verdict finding or sentence, any of those things. Is there a standard for that under Rule 33?
I don't think it's permitted. I see that the Rankin case, that clearly happened. I know the finding of timeliness wasn't made by the trial court, it was made by the law court. I think that's significant. But other than the Rankin case, I'm not familiar with other cases where lateness was excused when no additional time was requested within that 14-day period.
Well, what if it's something that is pretty indisputable about the jury? Like one of them turns out not to be an American citizen, or for other reasons just isn't qualified to act as a juror. Then what do we do?
I had that case. I argued that here, State versus Guyette, because we live up near the Canadian border, and once in a while we'll get Canadians. And there wasn't a standard question about whether you're a United States citizen. I think this was back in like 2011, and nobody brought it up. And it came down, and everybody kind of laughed about it, and then we moved on. And it was vacated on a different reason.
So we never reached the question?
Never reached the question.
Well, it would be kind of a problem if a lot of people on a jury aren't U.S. citizens, wouldn't it? I
think it would. I was a defense attorney at the time, not a prosecutor, but it definitely happened that day. I think that would render somebody not qualified. That could be a structural issue. But in this case, everybody was equally qualified.
Right, but it also wouldn't be limited by any timing problem, would it? If you found out years after the fact that they all happen to be a bunch of Canadians, then what, we couldn't do something about it?
I would not want to concede anything for the entire state, but there are some problems that are bigger than others. And, you know, in this case, the information that we have about this particular juror is that he knew Attorney Collins, not me, 30 years ago, and they haven't had much contact, and that he can be fair and impartial in a case involving Attorney Collins, who wasn't even involved in this case.
There don't appear to be additional questions.
Thank you.
Mr. Smith, if I move to the merits of the case instead of the timeliness issue, I mean, it does seem, I'm looking at Watts, which it does seem that that's an example of a case where the alleged juror misconduct, the alleged bias, failure to accurately answer on a questionnaire is frankly greater than it is here, and we still said that wasn't enough.
Right, and really the focus of our argument isn't the juror bias issue. I think that is part of the cumulative effect, but really the main thrust of Mr. Rosario's argument is that an alternate juror was allowed to deliberate with the regular jurors, the 11 remaining regular jurors. And when you look at the cumulative effect, that's really the basis of the argument. As I listened to Mr. Hunter's argument, I think the narrow distinction that we were asking the court to draw here is that this is a structural flaw with the trial that was discovered or at least raised after the fact. And when that happens, trial courts have, and this court, has some inherent authority to consider whether to address that issue. And that's what the trial court below did. It had the opportunity to deny the motion for being untimely, which it did not. And now the issue is here before this court.
Your centerpiece is really the structural error point, is that correct? I mean, this isn't a juror bias case, because the juror apparently knew the district attorney from 30 years ago. That could cut both ways. I mean, you really don't know if the juror had a bias in the first place. It might be favorable or unfavorable. We don't know. So this is not remotely a juror bias case.
No, the real focus here is the improper discharge of a regular juror and the allowance of having an alternate juror take that person's place with there being no statutory basis under Maine law for doing so.
So structural errors are not waivable, correct?
That's correct.
Wasn't this effectively waived? You said that the trial court has a responsibility, but doesn't defense counsel have a responsibility as well?
Well, absolutely, and I see this situation as being no different or perhaps worse than other circumstances of structural error. For example, members of the public get excluded from the trial. Not the entire public, but maybe just a few individual people. Now, just standing alone, that doesn't make the actual trial itself unfair necessarily. It would be very difficult to point to prejudice resulting to that by the defendant, yet that's an example of a situation where reversal would be required. And in this case, we have a defect with the actual jury, the people who are deciding the defendant's fate. So under those circumstances, I think an automatic reversal would have been appropriate.
Thank you, counsel. Thank you for your argument in this matter. As is our usual practice, we will be taking the matter under advisement. We'll issue a decision in due course. And with that, the court will be in recess on this matter.
All rise.